Thank you, Jeffrey, for the introduction. Indeed, my name is Anastasia Nefeli Vidaki, and I am a PhD researcher at Cyber and Data Security Lab in the Faculty of Law and Criminology. So you can tell by this that I'm a legal scholar, I'm not a technician, so I will try to develop my speech regarding the legal aspects of web harvesting in a more comprehensible and maybe less legal way. To begin with, I would like to define the two main terms that you can see in the presentation, namely intellectual property and privacy. By intellectual property, I mean mainly copyright and its related rights, the right to reproduction and the sui generis database right. And by privacy, I mostly refer to data protection. So without further ado, let's get to see the concerns one by one, starting by copyright. Copyright, as you might already know, is a legal right that is granted to an author or generally somebody that has constructed a work. It's the right to exclusive publication, production, sale or distribution of any literary, musical, dramatic or artistic work. For a work to fall under the copyright regime, it needs to be original, meaning it constitutes the author's own intellectual creation. Copyright can also apply, as you might already be aware of, to software, databases, and other collections of works if their selection is regarded as original. Taking into account the already developed scope of the copyright protection, we can say that raw facts and data are not eligible for copyright protection because they lack this creativity criterion I talked to you in the beginning. Moreover, although public sector information may appear to meet the originality standard, they are explicitly excluded in some EU countries and can be freely used. As you can already say, the data that are subject to web crawling might be protected by copyright. Websites typically featured copyright works, and the organization and compilation of their content may also be protected as original compilations. However, official data or pure information in the public domain may not fall under the copyright protection. Apart from the copyright, we have some exclusive rights of which it compromises, and among those, I think the most relevant for today's presentation is the right to reproduction that you can see in the middle. The reproduction right, it is defined in the InfoSoc directive, in the directive of the European Union on Information Society, and it is the exclusive right to authorize or prohibit direct or indirect, temporary or permanent reproduction by any means and in any form, in a whole or in part of a copyright-protected work. Accordingly, web crawling fundamentally involves reproducing web content. So if websites which are being crawled feature unauthorized content, such as but not limited to the content uploaded without the consent of the right holder, the individual conducting the crawling activities may also be held accountable for copyright infringement. Keeping this in mind, I will briefly present the last right, the database one, which is the right to limit the extraction and reuse of substantial parts of databases, repeated and systematic of non-substantial parts of databases as well. This right is defined in the database directive, and the protection lasts for 15 years, so we can tell regarding the contemporary feature and character of the internet that at the current moment, most sites are protected as databases. As long as the 15 years have not passed. We see that there is such a protective regime regarding the copyright in the EU. However, we are confident that there are a few exceptions that can be proven really useful to the people implementing web harvesting. Among those, we have some mandatory ones, which is the temporary reproduction and the text and data mining exception. And we have some optional ones, the research exception and the quotation and privacy copy exceptions. The research exception also applies regarding the database right. All the others apply in relation to the exclusive right of reproduction, which I presented to you beforehand. So we will go through them quickly, one by one, and see if they are relevant for web scraping purposes. Starting with the exception of temporary arts of reproduction. In Article 5 of the InfoSoc Directive, temporary acts of copying, including those made during data capture, are to be exempted from the scope of copyright and of the reproduction right when they are transient, incidental, integral part of the technological progress, and they appear not to have any independent economic significance. We already know that the web crawling workflow as data capture process involves temporary copies of works, which are not, though, always ephemeral. The reproductions occurring during web scraping activities are most often intended for use beyond the crawling operation, and their distinct financial value of such acts of reproduction in the frame of web harvesting cannot be overlooked. The output also of the web crawling procedures can be traded or can be financially exploited in many other ways, such as but not limited to licensing. As a result, I think it becomes quite obvious that the requirement of absence of independent economic significance is most of the times not fulfilled for web scraping activities. Although we can say that it might be feasible to organize the web scraping activities in such a way that it meets those criteria. In terms of reproducibility, this method might not be ideal. Therefore, I reckon that this provision is not able to provide us a viable and legally stable solution for web scraping activities. Taking that into consideration, I think we should check upon the research exemption. This is fulfilled only for scientific purposes, and it must solely, the reproduction must solely serve the purpose of the research. And as you can see, it must be non-commercial. For the one using the data that are protected under copyright, it remains necessary to indicate the source, including the author's name, which, in my opinion, is not always really easy to track. So applying the requirement for the justification of purpose and all the other prerequisites that you can see also in the slides to data-intensive research as the web scraping one remains, I think, contentious. And also distinguishing from the useless and the useful data beforehand might end up a really difficult task. Overall, the conventional research exception, as the one I presented to you, offers limited elevation for web harvesting. So it is high time to check the quotation and privacy copy. These exceptions suggest that the lawful quotations and copies that are intended only for individual, for private use, can be rendered lawful. At the first glance, those exceptions might appear not at all applicable for web harvesting. However, taking into account that crawling sometimes involves reproducing web content, it can be likened in terms of copyright law to make quotations or to make copies for private purposes. However, both of these exceptions, in my opinion, do not offer viable solutions for to avoid copyright infringement as well. So we may pass to the latest one, the one on text and data mining, which was introduced quite recently in 2019 by the CDSM directive, the Directive on Digital Single Market. This is introduced in Article 3, and in particular, it allows reproductions and extractions of works without prior authorization of the right holder if they are done by a small group of beneficiaries, including scientific and artistic institutions for those purposes. And there is also an opt-out mechanism available for the right holder. For example, the right holder might be able in some circumstances to refuse the use of their work. This exception does not take into account the idea and fact expression doctrine. So in my opinion, and according to the research, it might not be proven ideal for the web scrolling purposes as well. So apart from the copyright concerns I explained to you about, we have the data protection ones. When we talk about personal data in the EU, we talk about those data that are able to make a person identifiable, at least, or identified. They can be also sensitive data, and where we're talking about data processing, we mean all those acts that can be enacted on captured data by the data controller or the data processor. People involved in web crawling are, in most of the cases, data controllers, but can be data processors as well. Those have to obey to specific principles and take into account the rights of the individuals and some obligations already posed by the GDPR. Among those principles, I consider as the most important the ones of lawfulness, the ones of consent, and data minimization, which can be sometimes triggering for web crawling procedures. And apart from those, the storage and the purpose limitation, which can also put a hinder for web crawling activities. Regarding the rights of the individuals, I think the right to be forgotten is the most important one. It's in Article 17 of the GDPR, and it is raised in many web archiving and web scrapping procedures, since it gives the opportunity to the to the person that owns the data to ask for the erasure for some specific reasons that are prescribed in the law. And last but not least, the GDPR somehow poses some specific measures that should be followed in terms of design in terms of design of data protection by default and by design as well, for keeping the records, and also for the implication of data protection impact assessments before such activities. And last but not least, it offers some solutions for technical measures regarding anonymization or pseudonymization, in case the first is not applicable, that are also to be taken into account. To conclude, after we have gone through this whole mapping of the legislation, I think we should see some practical recommendations for those people that are interested in carrying out web harvesting activities. First of all, after the capture of data, I think it is really important to check if they fall under any intellectual property regulation, if they are protected by copyright law or by any other related right, like the one of database or the reproduction right I talked to you in the beginning about. After we do this, it is really important to check if they fall under any of the exceptional regime, if they can be regarded as text and data mining procedures, if they are in the context of research, or if they are temporary acts of copying. If they fall under it, we can say that from the copyright manner, it is safe to proceed with the web scrapping activities without asking for the authorization of the right holder. Otherwise, in any case, you have to come to contact with the right holder and ask for their permission to proceed to do so. After it, regarding the data protection, we should always check whether the data we're using fall under the protection of GDPR, if they're regarded as personal data. And if it is so, we have to take into account that we should follow the principles and the obligations that are prescribed in the GDPR. Otherwise, if they're anonymized or if they cannot lead to the identification of a person, we can freely proceed with the data capture and with any kind of data processing freely. After giving you a little bit of practical guidelines that I hope they would render helpful in the future, I would like to thank you for your attention. I hope I didn't tire you with all the legal provisions quotations, and I hope that it will be in the future a really nice discussion. And you can also have the email. You can pose me any questions or any inquiries that you might have. Thank you very much.